Article 9 of the Uniform Commercial Code, or UCC, governs secured transactions and includes rules regarding the creation and priority of security interests. In Peerless Packing Company versus Malone and Hyde Incorporated, we explore whether creditors can use equitable doctrines to circumvent the UCC's provisions. Malone and Hyde Incorporated subleased a grocery store to John Kizer, sold him equipment, and supplied him with substantial inventory. In exchange, Kizer executed a promissory note in Malone's favor for $387,000, using the store's present and after-acquired inventory as collateral. Malone complied with the UCC's requirements for perfecting its security interest, a process providing third parties with notice that Malone had an enforceable interest in Kizer's property. Once Kizer's store was operational, Peerless Packing Company and 11 other wholesalers supplied inventory on open credit. They didn't obtain purchase money security interests, meaning they didn't take a security interest in the inventory supplied as collateral for Kizer's indebtedness. Kizer's store wasn't profitable, and he eventually missed payments to Malone. In exchange for Malone releasing Kizer from any liability, Kizer signed an agreement transferring all rights in the store, inventory, and equipment to Malone, plus the $64,000 in the store's bank account. Malone then notified the wholesalers that the asset transfer was the realization of its security interest, and it therefore took ownership without liability for outstanding debts. The wholesalers sued Malone. Among other things, they asserted an unjust enrichment claim based on Malone allowing them to deliver inventory after it decided to foreclose. They also alleged that Malone failed to comply with the UCC's provisions for realizing its security interest. The trial court rejected the arguments, granting a directed verdict in Malone's favor. The wholesalers appealed to the West Virginia Supreme Court of Appeals.